Guys, welcome to another video. And as usual, before I get started, go ahead and smash that like and subscribe if you're new to this content. And to my current subscribers, I appreciate you guys more now. Let's get right to it. So at the time of making this video, we all know that Bitcoin is actually starting to really starting to make that run for it. It's roughly around the 71,000, 72,000. But tonight, I'm actually not going to be talking about meme tokens. I'm actually going to talk about Safemoon. And there's a letter that's actually been released to address to the clerk of court where John Karuni was most likely tried and was gotten bail, and we all know innocent until proven guilty. But this letter is actually really critical. I'm actually going to go ahead and mention this letter right now. But it's a letter that's actually written on behalf of the Safemoon community to the clerk of court. Even though there's a bankruptcy case going on, they want to know what is going to be the well-being of the liquidity pool. We do understand the fact that in a case of a bankruptcy, the creditors will most likely come forward and say, hey, Safemoon actually owes money, or we're doing some business with Safemoon, we should be compensated. But what's going to happen to those persons that didn't get a chance to sell because maybe they were off or overseas working, didn't have access to get to their wallet to sell because the wallet was actually decommissioned, as well as maybe some person was off to the military doing things and they don't have access to go ahead and take advantage of selling and getting their money out in time. So as a result, a letter was written, again, on behalf of the Safemoon community to see where is the court position on the LP, okay? Are they going to take all the funds and don't allow them to do a class action lawsuit? Anyway, that is what that letter is actually pertaining to. And I'm going to go ahead and read a little of the letter, and I hope you guys listen all the way through to the end because, the Safemoon community, even though, Safemoon is in a situation where it's actually, for lack of a better word, pretty much dead right now. But the community is still strong because this does not mean that the company cannot be resurrected. I know a lot of people are going to say, you guys are crazy if we keep thinking about that. But what I want to let you guys know, if you are a business-minded person, doesn't mean that a company going bankrupt means that the company cannot be resurrected. It can actually be purchased by somebody else, a third party, rename it, relaunch a company, and hey, voila, the company is actually going up. So let me just get right there. So the letter goes as follows. And guys, pardon me, guys. I'm going to try to read through this as quickly as I can because I don't want to make the video too long. But it says, please find and enclose a letter addressed to the Honorable Judge T. Maker regarding the case for Safemoon LLC. I kindly request your assistance in ensuring this letter is properly directed to Judge Maker for his consideration. Dear Judge Joel T. Maker, we, the investors of the Safemoon LLC token on the Binance blockchain, representing a global community of over 1 million individuals from diverse regions, bring forth our concern regarding the ongoing criminal case involving Braden John Karuni, the Safemoon LLC bankruptcy proceeding. So, for those of you that are not aware, John Karuni was incarcerated for over 3 months and he's now on bail. The community wants to know the well-being of how things are progressing, in addition, the finances of the LP. So on December 16, 2023, trading of the Safemoon token was abruptly paused without official communication to investors, followed by the unsettling removal of the liquidity on February 7, 2024. The action was involved with substantial, some belonging to Safemoon investors have raised alarm among the community. We firmly believe that in a bankruptcy scenario, the primary objective should be to repay the creditors and safeguard the investors' interests. Funds within Safemoon LLC, including those in the liability pool, must be protected from unauthorized use, including payments of trustee wages and legal fees. I totally agree with that. This is investors' money, okay? You cannot take the investors' money and go pay the lawyers. I mean, that's not the whole objective of why the investors put their money into Safemoon, is to make life-changing wealth, okay? That's the whole objective. If all of the projects have actually come to fruition, and if none of this has happened, hey, a lot of us will probably be on the beach right now actually enjoying ourselves. But things just went sideways. So the investors, like myself, do not want the court to decide to go ahead and use the money, to completely use it out until there's nothing else and pay everybody else. You must give the holders a chance and the community a chance to therefore go ahead and do a class action. So I really hope that the judge actually take this into consideration, because a class action lawsuit is a serious matter, because now the very thing that you're accusing the CEO of, almost as if you guys are doing the same thing. So letter also goes on to say that, as investors, We place great emphasis on the role of the regulatory bodies, such as the SEC, in protecting our interests. We urge the court to align with this mission and exercise strict oversight to prevent any misappropriation of investors' funds during the bankruptcy process. That is critical, guys, because, the Safemoon community, yes, they're already burdened with a lot of the situation that has happened. A lot of people throw a lot of shade. And hey, we get it. It's not a good look, the way in which how things actually turn out. We are not blind to that whole situation that happened. We want our money. We want to make sure the money is safeguarded. So just in case if maybe the company was to be acquired, maybe they can use that funds and go ahead and roll it into the LP, because it will be the same community and the wallet address can be transferred over to that new third party, whatever. Or if that's not the case, then pay the Safemoon holders in full the amount that they put into the LP. That's with proof of the wallet and the transactions. They should be compensated. Do not spread the money out. Again, let it continue to go on. As an estimated total of $2,513,620.09 in investors' funds comparing various cryptocurrencies has been removed and currently held in a wallet by a given address. We request clear oversight to ensure the transparency and accountability in the handling of these funds. I totally agree. We want to know what's going on. We don't want to know that you guys took the LP and then paying the legal fees. Again, that was not the plan. The money was not supposed to be used for that. It belongs to the people. And that needs to be addressed, okay? It needs to be addressed, and the court is actually going to enforce the rules and the law of the land. You must take care of the investors as well, because their intent was to go ahead and make money of this. They also go and says that, furthermore, we employ the court to consider the implementation of the ongoing criminal case against Braden John Caruni. A verdict in his favor would signify the preservation of his efforts and investors' faith in Safemoon potential. Conversely, premature actions such as removal of liquidity could unjustly hinder Safemoon future proposal. Agreed. Because, the LP is the net worth. All right? How much is the company worth? You as much as the company's value is what's in the bank account, as well as the assets that it has created. The Safemoon wallet, the Safemoon exchange that already got launched, that was pending, the Safemoon blockchain. That is a turnkey operation. If someone has the money, they can go ahead and buy the complete package, the bundle, and go ahead and rename it. This is prime and ready to be taken over by somebody else if the court go ahead and allow this to happen without dividing it up. And whoever that person is that go ahead and acquire Safemoon, that is going to be a very, very lucky person. Goes on to say, despite the debt to the assets ratio indicative to the bankruptcy, we advocate for the preservation of the liquidity pool and the Safemoon product. With additional company assets exceeding $5 million, we believe there's a sufficient resources to cover creditors' expenses without compromising the liquidity pool. I agree as well. In closing, we, the investors, comprising individuals from all walks of life, respectively urge the court to await the outcome of the criminal case and exercise prudence in any action that may impact Safemoon community and success. Sincerely, Safemoon LLC token holders. I think this is a very, very powerful letter, and I think this is one that was actually needed. And I applaud those who actually put this letter together, because I think the holders were actually being ignored at this point. They were focused on, the person who was a valuable asset, and the trustee was looking forward to making sure that this person is being paid. There was no mention what's going to happen to the investors who invest in. There was some information leading up saying that, hey, go ahead and take your funds out. I did remember something coming from the trustee and all that, but you have to take into account that those people that didn't have a chance to sell, are you guys going to reimburse them? And the misappropriation of funds seem as if, and I hope it's not, that it could very well be happening now, that funds is actually going towards legal fees. And that is not the case. I hope this letter finds everybody well by bringing this letter to you guys. And hey, Safemoon community, I was a little busy, but I did see it in the Twitter post to go ahead and talk about this. And thank you for bringing this to me, because this is one that's actually really, really important that I think everybody needs to know what's going on with Safemoon, even though we know the situation. And I'm confident that if the company actually is acquired by some other third-party company, there's a high chance it could be divided up into pieces, and it's okay, I cannot afford the entire package. I'll go ahead and maybe just buy this component. And if the court allows that, that would actually be really, really good as well. Whoever gets the exchange, that'd be really, really good as well. And whoever gets the blockchain, fantastic. Now, there's been no mention that they're going to go ahead and dissolve the situation. Hey, this doesn't even pertain to the CEO. He already has a battle that he's dealing with, and I think he's pretty occupied with that at the moment, okay? But this one is addressed specifically to the holders, that we want to know what's going to happen to the money. And I think the court needs to address this, and this needs to be addressed quickly. And they need to make note of this, that, you know, this can be a case that the holders can go ahead and most likely retain an attorney to go after this LP. And this whole thing can actually turn upside down. So hope you guys enjoyed the video. Like, share, subscribe. Let's get this out to the Safemoon community. Let them know about this letter. And until I see you guys again, you guys have a wonderful day.